Good morning, real estate agents. Welcome to another edition of the Broker Roundtable, where we come to you each and every month with an array of experienced brokers in the Valley or legal minds just to kind of deal with the issues that we are facing as real estate agents. I remember December 31st, 1999, we thought the world was going to come to an end. My kids have no idea what Y2K means. I remember when we had the end of the Mayan calendar and we thought we were going to all disappear on the face of the planet. And so now February 1st, that's the next big date where the world's going to fall apart. The earth is going to come down crashing upon us. That is when we get the brand new revised. I don't even want to call it brand new as much as a revision to the Arizona residential buyers purchase contract. And so we have with us today, we have Marge Lindsay, who has got more experience than anyone that I know. As a matter of fact, at the very beginning of time when God said, let there be dirt, she was standing over his shoulders and pretty much told him where to put it in a kind way. And we also have Scott Drucker here with the Arizona Realtors Association, and we were going to have Rick Mack here today, but apparently I'm not very good at my communication skills and so forth. So I never actually told him when it was. I just asked him if he wanted to be on one. So anyways, Marge, Scott, welcome to the Broker Roundtable. Appreciate you joining us today. So let's get going. February 1st, revised contract. Am I correct in stating it that way? It's better to say it's a revised purchase contract rather than some people are saying it's brand new.
I think it is. I think it's very appropriate because when we as practitioners see it, yes, there are a lot of changes, but a large percentage of this remains just as it's been. So it is a revised version of the purchase contract. And sadly, I shouldn't say sadly, good news is it's happening because it's been almost 12 years since the last time, we had anything with a major revision like this, because it was in 2005.
We've made some small changes as the years have gone by, especially, the TRID changes to the financing section. But you're right, it's been a long time since we've looked at the contract as a whole. And fortunately, it's not an entirely new contract. I think that would be overwhelming for everyone. And so all we've done is made some revisions. We looked at the current version of the contract and said, where can we improve it? Where can we add clarification? How can we remove ambiguity? And that was really our goal.
And it's important to say that throughout the webinar today, you have the ability to send us messages, questions. So if you'd like some questions for me to ask the panel, and I need to emphasize that I will be asking the panel because you do not want my answers to these questions. There's a reason why I am not a designated broker, an associate broker. And then I should have also emphasized that not only is Scott Drucker with the Arizona Association of Realtor, but he is their general counsel. And it's always fun to say attorney jokes and lawyer jokes, but they're a lot more fun when you need them. And so Scott's here to help us stay out of trouble as well. So Scott, let's start with you. Why in the heck and what brought the risk management committee to come together and say, let's revise the purchase contract? So I think we should set the foundation of why.
Yeah, and we talked a little bit about it from the standpoint that it was time because it had been a while, and
if my wife said that, say, "Honey, I'm replacing you because it's time," it's going to be hard for me to swallow.
Oh, I'm sure she would understand perfectly. I can't imagine any objections. Over the years, though, problems present themselves with the contract. We learn as we go, and so we continue to make notes and recognize, okay, this provision is being interpreted differently than what we thought. This provision is leading to disputes between buyers and sellers. This provision isn't as clear as we'd like. And so we make notes of that. And then finally, it was time to take those notes and to make the changes.
Any thoughts on that, Marge?
No, I totally agree with him. We do make the new forms and or revised forms available 3 times a year through the Arizona Association of Realtors with an exception, and that is if and when the law changes, we'll go back now and make that change. And the first one that comes to my mind, and if Scott can think of anything else right offhand, but the first thing that came to mind was when we changed the limits on small claims court, when that was upped from $2,500 to $3,500, we went in and we made that change immediately.
Another one would be when the FERPTA withholding, right, was increased from, the maximum was increased from 10% to 15%. That
Yeah,
was a
on
change
February 1st.
Right, that was a change that was required by law, so we went in and made that change.
And a lot of times people, we take these changes and these revisions personally. We're like, okay, now everybody's trying to make my life complicated. In some respects, these changes help us as agents, and we need to understand how they're to protect us. So how common is this scenario? And this scenario, I'm is probably going to change February 1st. So I go out and I represent my buyer. We write an offer on the contract, and I put in the offer that I am in possession of $2,000 earnest money check, but I don't really realize that the contract says I'm in possession of it. Buyer skips town, changes their mind. There is no earnest money deposited with the title company. And now the seller's coming after me as the buyer's agent going, hey, well, you said you actually had the earnest money. And that now changes in Section 1C.
Yeah, there was always two things about the earnest money provisions in the 2016 contract that bothered me. One was the location, right? Why did we list the amount of the earnest money on page 1, but we didn't talk about the earnest money until page 8? And then, of course, was the statement that you're right, that the earnest money has been received by the broker, when vast majority of times that's not the case. I mean, think of a wire transfer. Is that broker ever in receipt of the money? And to answer the specific question that you've raised, I've certainly litigated my share of those cases. I think Marge has probably testified as an expert witness in some of those cases. I had the largest one was we were representing an agent. They didn't secure the earnest money, and it was a large amount of money because the transaction was for an entire town in southern Arizona.
Wow!
And so it was a lot of money.
Yeah, I was going to say, one of the things that I say when I'm doing classes frequently, one of the things that I will tell salespeople and would state now, never put down that you have something you don't have. And, when they say, well, I've got the earnest deposit, because it does state, like Scott said back on page 8, that it's been received by the broker named in Section 8R, that sort of thing. And there were times when they didn't have it. They were waiting for money to be wired, or they were waiting for a FedEx delivery because they hadn't remembered their checkbooks. I mean, there are a lot of different scenarios. And then when that buyer bolts and is gone, the seller would come back after the agent because it was the agent who said, I have it. So I've always said, never put you have something that you don't have without explanation.
But I think it gets worse than that, or goes deeper than that, Scott. It's how many times did the buyer's agent learn that that's what they said, that they were that the contract said they were in possession of it. They learned at the time that they all of a sudden got notification from the seller, hey, by the way. So I agree with you, Marge. I would never say that I have something that I don't, but a lot of agents never even realize it was in there because they never read the contract.
And that's the key right there. Read the contract. The answers are in the contract if you just take the time to read it. But the good news is we've made some changes, right? We made the changes to the two sections that we just discussed. The earnest money section that was on page 8 of the purchase contract has now been moved to page 1, which I think makes a whole lot more sense. And we did, in fact, remove the language in the contract that stated that that the broker was in receipt of the earnest money.
I think it would be a lot easier if we could hire James Earl Jones to just narrate the purchase contract on tape, and we could just drive down the road and have Darth Vader tell us where the earnest money is, right?
If you get a hold of him, I'll set up the recording.
All right, another big one, kind of minor, but I like this a lot, and I know you guys could give a lot of emphasis of why this is important. But in Section 4A of the purchase contract now, the SPUDs the seller shall deliver the completed SPUDs from form to the buyer within 3 days of contract acceptance. Very small part of it, but this is a big deal, Scott.
It is. With the removal of warranted items, which I'm sure is something we'll talk about.
Oh, today. We're going to get to warranted items, yeah.
Home inspections have become more important than ever, and this change was made to help the buyer. I think that the reality is that the buyer is able to more effectively inspect the property with that SPDS in hand, and so we wanted them to have that seller's property disclosure statement for a longer period of time during their inspection period. And so again, the change was made to help the buyer.
All right, so let's just jump in. I mean, this is the big one. People, and I remember Trid. We were all freaking out, and I, and the timing and stuff like that, and we all, for the most part, got used to it. Those agents that became licensed after that, that change in the purchase contract definitely benefited because they only know life as it currently is.
They never knew the difference.
They never knew the difference.
True.
I think, as far as understanding, I think the removal of the seller warranted items, I think it's going to create, in my personal opinion, a lot of confusion of what this means and so forth. So let's start. Why was the seller warranted items removed? And it is, and if you haven't heard, I'm telling you right now, it's been
Breaking
breaking
news.
news. It has been removed. And for some agents, they're excited. For some agents, they seem like it's a really bad idea. And for the rest of us, we're not quite sure how this plays out for us.
I think overall, it's, at least in my experience, and Marge, you can comment on yours, is that it has been very well received by the agents, and especially the agents that are doing transactions on a day in and day out basis, because they know the problems that warranted items have presented over the years. And specifically, warranted items, it's very difficult to define what's warranted and what's not warranted. And we've seen buyers and sellers having a difficult time establishing or agreeing on what's warranted and what's not warranted. And of course, we cannot create a list or an all-encompassed list of warranted items because there's thousands and thousands of components in a home. And then even when the buyer and the seller could agree on what was warranted, they couldn't agree on whether it was in working condition. And working condition is a very difficult term to define. And so it seemed that we had reached the point where it was causing more problems than it was worth.
And what's kind of interesting is we didn't have warranted items in the purchase contract. Some have said, well, it's been that way in Arizona forever. No, it hasn't. But maybe because they're not quite as old as me, and I just thought I'd add that before Mike does. But we didn't have that in our purchase contracts when I started, and for a good number of years we didn't have it. And when we did, it was chaos because we ended up, from the get-go, we ended up with the same kind of confusion and the ambiguities. And okay, so if the one that I think is kind of fun, and we talked about it at one of the industry partner conferences, and Scott and Rick were up there and we were talking about this, and that was, I've got a kitchen sink that drips, and that's a warranted item. We want the seller to fix it. The seller says, the water's there, the water's working, the faucet's working. Nope, I'm not paying for anything that we're going to do, or we're not going to do anything with this. So then the question became, okay, when is it functioning? When is it not functioning? And if you can get water and that's what it's intended for, fine. And then the other side says, well, no, wait a minute. It wasn't built to drip. So it isn't functioning as it should. It therefore is warranted. And you go back and forth. And Rick's comment at that particular time was, and the thing is, we have a big to-do and blow up and a lot of legal expense in some cases because now they're angry and go someplace else over a 69-cent washer.
So let's talk about that example and what really happens when that occurs. They can't agree on whether it's warranted. They can't agree on whether it's in working condition. So what do? Well, they sit down in the vast majority of cases and they just negotiate it out, right? They come to some sort of agreement. That's all that's going to happen now,
exactly.
Right? I don't think it's going to be as big of a change because with this revision in place, all we're asking the parties to do is just sit down and negotiate what's going to get repaired and what's not, which I think to a large extent is what's already happening.
What I'm curious about, Scott, because I know you've been presenting this all around the state in different areas too. One of the things that I'm hearing in classes and or with calls and or, with the realtor on the street, if you will, is that they're saying it now has become caveat emptor. It's now let the buyer beware. So even though we said in the past that isn't the case, it is now. And they don't have any negotiating skills or capabilities. And of course, that's clearly false. But I'm curious, have you been hearing that as you've gone around the state also?
To a limited extent. But, fortunately, buyers are provided with the opportunity to conduct their inspections, to perform their due diligence and make an informed decision when they're purchasing that property. To the extent that they want items repaired and the seller is unwilling to make that repair, they're not under any obligation to purchase that home. And if you have a buyer that wants to buy and you have a seller that wants to sell, the expectation is that they're going to come to a resolution, come to some form of an agreement.
Yeah.
You know, and I always joked you could probably stick 100 real estate agents in a room and did a survey. And we talk about seller warranted items being so ambiguous. You could start listing scenarios, and half of them would say, yes, that's a warranted item. Half of them say not. My favorite one is when going back to the sink, when the hot water handle is labeled cold water and it's reversed. Okay, and I actually lost this one. I got into an argument with Jesse Wolnick on this. I'm like, no, it's not working like I think it should be working. And she goes, do you have hot water? Yeah. Do you have cold water? Then it's working. And the ambiguity of this, you could not get a room full of agents to agree. But where you could get them to agree on are the big ticket items. And for me, the seller warranted items are to address issues like the AC unit and things like that. So do we lose protection from those things?
It's possible. Again, the expectation is that if that seller wants to sell that home, they're probably going to have working air conditioning, right? Or else they're going to have a difficult time finding a buyer. They're going to have a difficult time finding a buyer that's able to secure financing. So the expectation is that the repairs will be made. But if that's not the way that it turns out, if it in practice it doesn't work that way, we can make changes to the contract, right? None of these things are written in stone. We're going to try this like 48 other states have now tried in their contract, right? I mean, warranted items are, from our research, are only in one other state contract. And so clearly the trend is to eliminate warranted items from the purchase contract. And I think Marge and I have spoken with representatives from other states and discussed, hey, how did that change go for you? And universally, it was positive. And so we're expecting the same thing here. But if that's not the case, we'll give it a second look. We'll reconsider the issue.
Do you know the thing that I think I'm most excited about when they start saying caveat emptor and the buyer's going to be left out? I don't see it that way at all. Quite to the contrary, if I'm a buyer broker and talking with my buyer, what I see as a real positive is it's now going to open the dialogue that says, one home inspection is oftentimes not adequate. If they want information about a roof, if they want information about a pool or an underground sprinkler system or things that are outside the norm for most home inspectors, now I think we as agents are going to be far more likely to say, here's what you need to check, because you're going to have to put a list of the things that you want, that you found, and you want it to be as thorough as possible because there aren't those warranties. And I think that's going to be a positive.
And buyers aren't locked into a minimum 10-day inspection period. If buyers feel that they need more time to conduct their due diligence, ask for additional time, right? There's a line in the purchase contract where you can write a number greater than 10. And if that's what you think you need as a buyer, put it in.
Yeah, and I think too with that is one of the terms that is being floated around, and I'm not really comfortable with it because I think it's going to get some of our less experienced agents into trouble, where everybody's saying, okay, well now buyers are buying the property in as-is condition. And it's not as-is condition. To me, it's present condition because, for those of us that were around for the market crash, we were trained by the banks as-is.
No repairs.
No repairs. And then a lot of agents, they're shocked to learn years later that even if their buyer signs an as-is condition, doesn't mean they still can't ask for anything.
Right.
Everything it's still negotiable. You could still, as is. So what we're doing here is our buyers are buying it in the present condition. And so now how important are the inspections and more importantly, the final walkthrough?
The work group intentionally omitted the term as is from the purchase contract because it has a negative connotation and it has often the expectation that means the seller will not be conducting repairs, and that's not the case, right? The property, as you mentioned, is being conveyed in its present physical condition, but the buyer has every right to request repairs, and more often than not, you're going to see sellers agree to some form of repairs in order to sell that property.
Mm-hmm.
All right, so let's. Anything else you guys want to add about seller warranted items that I'm missing here? Because there's so much good stuff in the contract
I
here.
was going to say, not that I can think of, other than to just say it's not something to be afraid of. And I mean, back in '95, when we put in 322156, for the stigmatized property law, to many people, myself included, that felt just unethical. It felt bad. And then I personally was talking with the president of the association in another state, who said, "My gosh, why do you feel bad?" And I said, "Well, it's kind of like I should have to disclose these things." And he said, "In our state," and that happened to be New Mexico, but he said, "In our state, we have never had to disclose that, and we will never want to disclose that." And then you start talking to people from other parts of the country and find out that we were doing something that isn't normal, or it wasn't the most common thing in the past. And we started adjusting to that, saying, "You know what, that's good." Today, I'm so very, very comfortable with that and understand the rationale, and the way I present it makes a big difference. And I think that's going to be the same thing with the warranties, is I need to figure out, if I were to say it this way, I'd say develop your script. Know what you're going to say, know how you're going to say it. And if you have any doubts or questions, talk to your brokers or managers or someone who can give you some direction and help you with that.
All right.
And properly set your client's expectations.
Yeah,
right.
Absolutely.
It's a secret to life, set other people's expectations of you. So I tell people, don't expect much from me, and you'll never be disappointed.
And then you exceed them, right? I know in your case you do.
Every once in a while. Did get a question in from Sally here, and at first I actually laughed, but I'm like, hey, this might actually happen. So the question was, some agents have mentioned writing warranted items back into the contract on behalf of their buyers, and what are our thoughts, and is there a risk of overriding the boilerplate now? Literally additional comments going back and writing in what was in our previous contract.
I would say,
By the look of Scott's face, he hasn't heard that one yet.
Oh, I've heard it.
Have you?
I don't particularly care for it.
Oh, okay.
yeah. Well, my immediate reaction is talk to your broker, because I know we have a number of people joining us from different companies. Talk to your broker and know what your broker's policy is. What I would say is we wouldn't have taken it out if it wasn't with good reason. So to arbitrarily put it back in could be putting you at risk for a whole lot of things. And now you're that maverick. You're out there on your own and you're doing it. And I think it's a bad idea. I truly do. And would say to anybody, don't do it until you've talked to your broker.
And I would say, and I'm not the attorney here, but I mean, part of the reason it was removed, we already talked about it because it was so ambiguous. So why would you go write in additional comments?
Absolutely.
Bring something back that's ambiguous.
Before you put it in, think why we took it out.
Uh-huh.
And it was because of all of the problems, the ambiguity, the gray area that it created. And so are you just taking those problems and putting them right back into your contract?
All right. So we're going to jump to something else, and I want to come back to the contract. But since we're talking about warranted items, what changes should we be aware of to the Binzer now? And has there been changes in anything that affects us in reference to now that warranted items are removed from the purchase contract?
Well, I guess something that I'm particularly proud of, for the first time in my career at AAR, I actually got to make a form shorter, which is something I'm particularly proud of. The Binzer has gone from 3 pages down to 2 pages, because we were essentially able to eliminate large portions of page 2 of the Binzer, which was titled Notice of Non-Working Warranted Items. And so that's no longer applicable. And so we're able to remove that provision from the form.
Okay. Anything else that we need to be aware of?
Just that all of the, if you want to take a look at, there's a number of ancillary forms that have been revised based on the changes made to the purchase contract. If you go to AAR's website, which is aaronline.com, right on that front page, you're going to see a link to 15 different ancillary forms. And for each of those forms, you're going to see the final version of it, what it's going to look like come February 1st. And then you'll also see a copy of the current version with the edits in red line fashion. So you can very quickly look at the form and see what was changed. And so if you haven't taken the time to look at those 15 forms, go ahead and do so.
I was going to say, that's the thing that I am most excited about and pleased with, is that AAR did do the red line versions. So when I picked them up, even if it's just that we changed the date to show it's now 2017 for copyright versus something or updated in 2017. It might be just as simple as that, because not many of the forms had major revisions or major changes, and so that's going to make it easier too. The one thing that was surprised, somebody said, well, how are they going to change the wording on the as is addendum? It was simple. We eliminated the as is addendum. We no longer have it. But I love the red line version, and I would recommend that any of you, whether it's on the purchase contract or any of those 15 forms that Scott's talking about, get the red line version. With the final version, it's going to make it a lot easier for you to look at it and say, oh, how did this change? Now, do I have to bring myself up to speed to understand?
I would have actually, Scott, preferred a different color, because I feel like I'm looking at a college paper that I wrote and then I got back from my professor.
We actually had you in mind when we did that. We're like, what would be most familiar to Mike? And so that's why we went with red. But I know that some of the agents listening are thinking, gosh, 15 forms, that sounds a little overwhelming. Well, the reality is that the majority of those 15 forms, the only changes that were made were to line numbers or section numbers that were referenced to the purchase contract. So the majority of the changes were not significant in nature. They're just corresponding changes to line numbers or section numbers.
All right. That's a good question. So we had some changes to seller concessions. We've talked about, removing seller to warranted items. Was there any rationale behind Section 8 making all the blank lines an entire page?
Yeah, it's called formatting, and brokers hate it.
I love first of all, every time I see an agent, they love Section 8A. Every time you talk to a broker, they hate Section 8A, right? But I have a lot of agents that say, oh, so, you made Section 8A longer. Is the expectation that we get to write more things in now? And no, that's not why the change was made. The change was made solely from a formatting perspective. We wanted that last page, page 10, all of those, the names and the signature blocks, the 4 of them. We wanted all of those on one page. And in order to do that, we needed to.
So don't read into it.
Right, elongate page 8. That's the only reason it was made, was simply for formatting purposes.
All right, so let's go back to Section 1G. I think this is really important. Just the the fixtures and personal property. We've gotten pretty detailed on this, and we've added a lot of different things. And then we've also added some description portions when we're talking about the washer, dryer, and refrigerator. And obviously, this is a result of things that you have found over the years. And so give us the impetus of why we made this so detailed.
So the first thing we wanted to do was we wanted to actually define the term fixtures, and that's now a defined term on line 39. We had used fixtures, the word fixtures in the prior version of the purchase contract, but it had never been defined. So that was the first thing we wanted to do. The second thing we wanted to do was, you see the word existing on line 40 of the purchase contract. We wanted to make it clear that existing applies to existing fixtures, existing personal property, and existing means to operate, meaning remotes. And so if those things are not in place, they don't need to convey. And we were seeing a lot of buyer-seller disputes in regard to that. And so we wanted to add some clarification. And then the last thing we wanted to do, which kind of seemed obvious, and I'm a little embarrassed that I didn't think of it sooner, was to put all of these items in alphabetical order, just so it's much easier to find. So I think that was a positive change. And when
that would have taken me 3 hours.
Fortunately, we have people that help us with that, so we weren't able to. We didn't get bogged down with that too much. But the two items I think that are most significant in the fixtures and personal property section would be TV brackets. It's AAR's informal position for a long time had been that the brackets are fixtures, the television itself is personal property. And so now we've formalized that and put that in the purchase contract. And so if you've got a seller and they want to take those brackets with them, those TV brackets with them, they have to put it in the purchase contract. And the other, I think, significant change has to do with outdoor landscaping, shrubbery, trees, and unpotted plants. I was amazed that people actually took trees with them. They thought they had the right to dig up a tree and move it to their new home. I was shocked to hear the number of stories where that happened. And so we made it clear that...
And as a listing agent, you wouldn't even think to tell them that they could.
Right.
You would think that so far, I would never once think to sit down with my seller and just say, hey, by the way, You can't dig up the trees.
And I never thought there would be a seller who would even think of doing such a thing, but apparently it happens on a fairly regular basis, enough that we had to address it in the purchase contract, right? We had to specify that, hey, if the plant, if the tree, if the shrub, if it's in the ground,
The boulders.
right, it stays. If it's in a pot, it goes. And I don't care how big the pot is. I don't care if it's hooked up to a drip system. If it's in a pot, it's personal property and it goes.
Yeah, I was going to say, when we're talking about this, one of the cases that I worked on, a part of the claim was that they destroyed the landscaping and so forth because they actually hired a company to come in with a crane to lift these boulders and put them on a flatbed truck and take those while they had another truck coming in to remove. I've forgotten the names of the palm trees now, but they were rather expensive and they were large. And they said, no, we've had them since they were little and we're taking them with us. And I thought, oh my gosh. And
So do boulders go or stay?
Boulders would stay. They're outdoor
I've never
landscaping.
even considered that.
See, I know. Well, that's where Scott's saying it's amazing what people come up with.
And look, again, we tried to fill in some blind spots to the purchase contract, but it's impossible to address every possible scenario that may arise because we just simply can't think of them all. But the other change, Mike, that you referenced is on lines 55 through 62, which is we added lines for descriptions.
I love this. I love this because I've always trained agents. You got to snap pictures. Take pictures of the serial numbers of the appliances because, okay, it's open and shut. If washer and dryer are supposed to convey and it's written in the contract and they're not there, it's open and shut. Somebody's got to replace them. But it's when the buyer shows up and it's different.
Right. Or there's two refrigerators in the home and it just says refrigerator will convey. And inevitably the seller takes the one with them that the buyer thought they were getting.
Right.
And so we added lines for descriptions where we're hoping that the agents will now write in a description of that piece of personal property so that there's no ambiguity. And as you mentioned, I think a lot of experienced agents were already doing this. This is really to prompt maybe the less experienced agents to follow that.
But there wasn't
course of
room in
action
it for them to really, you just check a box. And that was the thing. You would have to use the additional terms portion or something to note it. Now with serial number, model, make, everything, you can just literally write it in the purchase contract.
Yeah, right next to the item itself. And so I think, as you mentioned, that this is a positive change and really will prove helpful in eliminating some of those buyer-seller disputes that we saw over personal property.
All right, what kind of changes are we seeing in Section 2 over financing and anything major that we should be in consideration of?
I think that the one of the more significant changes is simply, we had a blind spot in the purchase contract as to what happened when a buyer would submit a notice of unfulfilled loan contingency prior to an LSU being conveyed. The scenario is pretty simple, right? The parties sign the purchase contract with the pre-qualification form attached. Now, before the date on which that LSU is conveyed, the buyer is advised by the lender, hey, you've been denied, you're not getting this loan. And then the buyer turns around and issues the notice of unfulfilled loan contingency. The question was, well, is that notice of unfulfilled loan contingency effective? And the problem was that under the language of the 2016 purchase contract, the loan that was contingent, the transaction was contingent on them getting the loan described in the LSU, but no LSU had been conveyed. And so now we changed the language, and you'll see it on line 70 to 75, making it clear that, hey, now the loan is contingent on you getting the loan described in the LSU or the AAR pre-qualification form, whichever is delivered later. So in the scenario we just talked about, even though the LSU hadn't been issued, if they were denied the loan that was set forth in the pre-qual, the cancellation would prove effective.
Okay. One thing we didn't mention, I want to go back to the fixtures and that sort of thing. I have a new policy. When somebody comes to my door trying to sell me solar panels, I just tell them to go to the website for the National Association of Realtors or call someone there, and if they can tell me it's a good idea, I might consider, because I'm finding one of the common things that I'm finding in the last couple of years is the issues of solar panels. Listing agents aren't necessarily doing their homework, don't know whether they're purchased, whether they're rented, leased, whatever the case is, and then what happens when the buyer comes in, and then sometimes buyers have an easier time qualifying for a house than they are for qualifying to take over the payments on the.
Sometimes you need a higher credit score to assume the solar lease than you did to get the loan.
So, any of the revisions in the purchase contract address that help us hurt it? What are your thoughts on solar panels?
Don't do them. No.
Okay, but I show up. I'm going to take a listing, and
I understand. Well, the good news is that AAR is only too aware of this and the issues and the concerns, and are presently working on a separate solar addendum. And I'm not sure when we anticipate that being finished, but yeah, there's a lot of homework that needs to be done with that. And if I'm a listing agent, at a minimum, I'm going to ask the seller, give me copies of any of the documentation that you have and make that available. Now, the interesting part is I, the realtor, am not obligated, nor should I do the investigation and the discovery, on these particular issues. I don't want to step out there and give myself more risk or more liability. However, having said that, I know and or should know that there are issues and concerns that need to be addressed, that prospective buyer needs to do this. Sometimes there's additional insurance that's required. Some homeowners insurance companies have said, you changed everything up there. You knowingly put holes in the roof. So they, in some cases, have had to go out and get additional insurance or a separate rider, separate policy or coverage for that. And like Scott said, and he wasn't saying it flippantly, sometimes the requirements are so great that somebody can't do it. There are some companies that will not let that original purchaser off the hook. They're going to remain, and they don't want to remain, liable or responsible when they sold the house to somebody else. And there truly are a lot of unanswered questions. My personal thought is, if I were to go back to listing and selling today, I would make any of those documents that I've requested.
You have to learn how to use a computer, Marge.
Now you're going to ruin it for me. But I would make them available to my buyer, but say to my buyer, you need to seek legal counsel. And I'm serious. I would just as soon put that off on, a good real estate attorney who can give them, whatever cautions and advice they can, because that's outside my area of expertise, in determining, is this good, is it bad? I don't know.
And I think that, there's a difference when the solar's owned versus when it's leased,
Absolutely.
right? It's
Yes.
when the seller owns that solar system, it is a lot less complicated. And under the purchase contract on line 52, if it's owned, it just automatically conveys. But as Marge indicated, where things become a lot more difficult is when the solar system is leased. And that's addressed on line 65 of the purchase contract, stating that, hey, if it's leased, it does not automatically convey. Now, the parties may contract for it to convey, but it can't automatically convey because, as you mentioned, they have to get approved to assume that lease.
So I've always, since you're the attorney, and I don't mean that as an insult, by the way.
It's too late. It's insult. Aren't insulted.
So this pertains to solar panels, but off the purchase contract, just out of my own curiosity. This scenario, and what's the worst case scenario for a buyer? So a buyer buys a house, at the end of the day learns solar panels are leased, cannot qualify, nor wants to pay for them. Seller is not going to pay for them, and now all of a sudden there's these solar panels and nobody's paying for them.
Right.
Okay, buyer has never agreed to pay for them. What's the worst case scenario?
I think the worst case scenario is the solar company comes and takes those panels off of your roof and has some damage to your roof, and now you've got some problems. I think that's the scenario that we're always afraid of. And then, of course, is the lawsuit from the buyer saying to the seller, hey, you didn't disclose to me that this was a leased item, and now you're going back and we're seeing disputes between the buyers and the sellers.
Yeah, I'm out money. I spent money on these things, and I wouldn't have had I known, that this was going to come up down the road.
And then the brokers aren't happy either. Somehow, I'm foreseeing that the brokers are going to get wrapped into this one somehow.
Absolutely right. And so the bottom line is, look, you look up, you see solar on the roof, make sure it's addressed in the purchase contract, because if it's silent, that's where we're going to see a problem.
All right. So line 111, appraisal costs. there's some red there. What do we need to? What changes were made as far as appraisal costs? Anything pertinent that we need to know? And then we can also then jump into 120 title investing, because I like the fact that we're kind of spelling this out, that you need to do a little bit of homework on this.
So I'll talk about the appraisal if you want, because the dispute that we always saw with the appraisal section is when the seller agrees to pay for the appraisal, when, right? When do they have to pay the money? And sellers always want to pay it at close of escrow. And the lender or the appraiser, they may demand the payment sooner than that. And so we had this, again, an ambiguity. It wasn't as clear as it could have been as to when the seller is agreeing to make that payment. And so now the language has been changed just to make it clear that, hey, you are agreeing to make the payment when it's due. Whenever they ask for it, that's when you're going to make the payment. Now, could that be at close of escrow? Yeah, it may be at close of escrow, but could it be before close of escrow? Yes. And then we also wanted to specify, oh, and by the way, if you make that payment before close of escrow and the deal doesn't close, you're not getting your money back. It's non-refundable. And that was something that we thought was important to specify.
Yeah, one of the things that I found kind of interesting was a salesperson who looked at this and said, well, now what you're pretty much doing is putting the burden back on the seller to have to pay for these appraisals. And what if they have 3 transactions that fall apart? Now they have 3 useless appraisals. And I said, well, why would you
tell them to lower the price?
Yeah. Why would you think that it's, indicating that it is to be paid by the seller? The very first line on 111 says the initial appraisal fee shall be paid by. And they could put in their buyer, and or the seller could, specify that it is to be paid by the buyer. They could then back on, the blank lines, though we don't want to encourage that, but they could state that the buyer is paying for the appraisal and the seller will reimburse the cost of the appraisal at the time of closing, which would eliminate some of those things, but that's no different than it was before. We always had that option or that opportunity.
And then, Mike, I think the other section that you referenced in your question was 3B, right? Lines 120 to 122. And all we were doing there is it's really a disclosure. It's a notification, and it's saying to the buyer, hey, if you are married but you intend to take this as your sole and separate property, a disclaimer deed may be required, because we want them to know that early on in the process, not be surprised to learn that at the closing table, only to find out that they're in the middle of a separation and the other spouse is refusing to sign it. If that's going to be the case, better they know it right in the contract from day one than at the very end of the transaction at the closing table, because that, of course, is a disaster.
Yeah, we said with this too, that's kind of one of the fun things, because we identified an oxymoron, and that was friendly divorce.
All right.
I thought it was funny.
Did you say something, Mark?
Yeah. No.
So section 4. I want to jump into 4C. So whenever I want to get, if I'm talking in front of a room full of agents and I want to get their attention, I start saying the word realtor with 3 syllables, because they'll like all stop and stare at me and start judging and things like that. I like to toy with them. And then if I just ever want to see a room full of agents look like deer in the headlights, sure, I mentioned FERPTA because it is because very few of us, are working with Canadian investors and investors from out of the country. But there's a lot of us that don't realize we are until the very end. And so let's talk about 4C, foreign sellers, and what FERPTA is and what changes there are, if any.
Sure. First of all, FERPTA is tough, right? It's complicated, it's technical, it involves taxes, all these things that we don't like. And the reason I mention that is, myself included, agents, we're not CPAs, we're not tax attorneys, we are not tax professionals. And so the critical thing to remember with FERPTA is, don't be giving advice that falls outside your area of expertise. Again, we needed to include FERPTA in the purchase contract because it's information that buyers and sellers need to be aware of. That doesn't mean that agents need to become FERPTA experts. And as a result, we put some language in that section in 4C, making it clear that, hey, Seller, you are responsible for obtaining independent legal and tax advice. And our hope is that, if an agent gets a question, that they'll say, hey, take a look at lines 165 and 166. This isn't something that I can answer. You've actually got to go and talk to an attorney or talk to a CPA to get that information. Now, as for the changes that we made to FERPTA, really all we did was we broke the FERPTA section into two separate sections. There's certain sections of the purchase contract that are more applicable to the seller, and there's sections of the purchase contract that are more applicable to the buyer. And buyers and sellers have different obligations under FERPTA. And so we put the seller's obligations in a section that's pertinent to the seller, which is disclosure. We put the FERPTA language that applies to the buyer in a section that's more applicable to the buyer, which is due diligence. And we specify in each one what that party has to do, right? If you're the seller, you've got to agree to sign and deliver to the escrow company the certificate. If you are the buyer, you have to withhold the income tax. And so we're just trying to specify, depending on what role you play in the transaction, changes your obligations under FERPTA.
And so where does I'm working with either a buyer or seller, and then I know that a foreign investor is going to be involved in this. I mean, generally we always say when you have questions, if my buyer or seller asks additional questions and for clarification of the purchase contract, I always say, well, okay, I'm not a real estate attorney, and you should probably speak with a real estate attorney, and not trying to be a FERPTA expert. Where would I want to send them to their CPA, or still to a real estate attorney, or both?
My reaction would be either or. And in some cases, it might be both. One of the things that I hear frequently is I talk to my accountant, and my accountant honestly doesn't know. And that's not uncommon. Just like us, we don't have expertise in all areas. And there are many CPAs out there that may not know about this. They've never dealt with it. And so it's an issue they don't know about. The good news is the buyer knows now, so you can refer them to an attorney. One of the things that I really like, and it isn't an oxymoron, is when we say in Arizona that we have good real estate attorneys. What I love when I've referred somebody to a Scott or to some of the other attorneys, the thing that I like is if it's outside their area of expertise, they will refer to someone that they know does handle it. And far better, that it goes that way than not. I know from a realtor standpoint, if we want more knowledge and we want some more information just to feel more informed and more aware, one of the things I love, when Scott gave you their email, or I'm sorry, the email address.
Website.
Website, thank you. aaronline.com. I love that. And there's a section in there to search. And you can put in FERPTA. FERPTA changes as of February. You can put in there FERPTA exemptions. And we have access to just a ton of good and valuable information. And so I'll often tell our salespeople, instead of me trying to explain it, go in there. Scott has written articles, Nikki has, Michelle has, and if they find something that's an update and timely, it's there, and they'll share that knowledge with any and all of us. So that's a good source too.
Well, I have 5 different CPAs on speed dial, and I just go down the line until I get the answer that I'm looking for. If I get audited, I'm not sure what's going to happen, but I'm looking for an answer, and who's going to give it to me?
As long as you find someone that's going to stand behind it, right?
Yeah. That's the next question, yeah.
I want to jump over to we talked about the warranties and things like that. But as far as the buyer disapproval, line 64 and the seller warranty, 264, line 264, and the final walkthrough and anything, are there any changes to the process of I don't like something, I want something fixed, and I need to ensure that it's fixed before I close escrow?
I don't think that there's been changes to the process. I think that the process itself...
Because I think that's important for agents to understand. There's no changes to the process.
Right, the process itself remains the same. All we did in Section 6J is we tried to specify a little bit, hey, this is what happens if you don't properly comply with the process, right? The contract makes it very clear that if you're submitting a BINSR, you have to give a reason for the cancellation. didn't in the prior version of the purchase contract explain precisely what happens if you submit a BINSR and you don't state a reason. And so again, our goal, fill in blind spots, eliminate ambiguity. And I think that that's what we did with the changes to Section 6J, making it clear that, okay, you submit a BINSR and it doesn't state a reason, the cancellation is still in effect. The cancellation remains effective. But seller, if you want that earnest money, got to issue a cure notice, give them 3 days to state a reason. And if they do, they're entitled to the earnest money. If they don't by the end of that 3-day inspection period, you get the earnest money.
All right. Oh, go ahead, Mark.
No, I was just going to say another thing that comes up frequently in this area are salespeople who believe, and or their clients who believe, that this is an opportunity for a free look on the buyer's part. Because they said, hey, all you have to do is look at this, and on line 267 it says, if buyer's notice specifies disapproval of items as allowed herein, the earnest money shall be released to the buyer. So they're saying, hey, all they have to do is disapprove something and they're automatically going to get their money back, which makes it a free look. Well, they've missed 3 words. And those 3 words are as allowed herein.
Okay, let's talk about that, because I used to have one of those pinwheels where if I had a buyer that we were going to write something and cancel the contract, just spin the wheel and see what excuse we're going to use. I'm kidding, Scott. I'm kidding.
Sorry, my heart skipped a beat there. Sorry. Yeah, but and the bottom line is, look, the cancellation has to do with the property, right? Can you cancel because your sister in Idaho is getting married? No. Can you cancel because the roof is in poor condition? Yes. Can you cancel because there's a registered sex offender in the neighborhood? Yes. But it has to be something, right, that deals with the property. The airport's too close. The airport's too far away. That's fine. Again, it has to do with the property.
Yeah.
All right. So we get 2 MMA fighters. We put them in the octagon, okay, of equal strength, equal skill. One represents the buyers. One represents the seller in the revised purchase contract. Who's got the advantage, and who would come out the winner?
The one who reads it.
The person who could exploit the contract the most.
The one who reads it and understands it. I mean, I am not kidding you. I had a call on Tuesday of this week from an agent who was asking me all of these questions and went through this whole thing. This isn't the way it ought to be. And I said, let me ask you just very directly and very bluntly, when was the last time you read this contract? And honestly, he said, well, I haven't needed to. Oh, yeah, you do, and so I think that's where the power comes. When we say knowledge is power, I think that's where it comes from. And Scott said at the onset here, read the contract because the issues are covered. They're addressed in here, but you got to know that.
And the reality is, look, at AAR, we have no agenda. We're not looking to favor the buyer over the seller or vice versa. Our goal is to create a fair and balanced contract, and I think that that's what we've done.
Because I think where the dangers are, and we see it all the time. We see it with the last 3 different revisions or the last 3 contracts that we have. The agent, and we're going to see it a lot more when the new one rolls out on February 1st. The agent who isn't aware of the changes is going to end up finding their buyer or seller in an interesting position, because their buyer or seller may be committing to something financially that they weren't aware of because of the changes, and then as brokers like to call it, commission breath. You say something and next thing you know, you're because at the end of the day, it's our commission. We when we don't read this and when we make the errors, the only thing that we really have is giving up our commission, much less our reputation and so
that's
forth.
If it closes, right?
Yeah.
Oh yeah, huh?
Yeah.
Yeah, I haven't really thought about it. Okay, any just last minute thoughts?
Well, one thing that I would love to ask Scott, and this wasn't a setup. I mean, I just now thought about it, and that is with Armless. Speaking for those who are a part of the Armless system, with Armless, they have wording in their contracts that talk about warranties, and it's going to need to be modified. It's going to need to be changed. And I understand that the goal right now is towards the end of February for them to have the revisions. That's what they're working towards. They meaning Armless. In the meantime, obviously, if I'm a listing agent, I need to let my seller know that these provisions and the things that it says are not there. And my question, Scott, is as I thought about this, I can tell them, but it's amazing how they develop what I call memories of convenience.
Sure.
So what would your thought be? Because I haven't even talked to our broker about it yet, but what would your thought be if we were to suggest that the listing agent strike that language
In
the actual form itself?
the ER?
In the ER form, yes, strike the language and have their sellers initial that.
I don't have a problem with it as long as it's approved by their broker. You
Okay.
know, one of the things we did is on November 15th is when we released the revised purchase contract for educational purposes. On that same day, November 15th, I sent an email to every association executive for the local associations in Arizona and every MLS executive in the state, letting them know, here's the revised contract. Please take a careful look at it because it may require changes to your listing contracts. And I know that many of them have made those changes, are in the process of making those changes. And so it's our hope and expectation that the scenario you raised isn't going to be around for very long.
Right.
That
Just a couple of weeks, hopefully.
if that, and
Right.
that the MLSs are working hard on this issue. And I know that they are because I've spoken with many of them.
Good.
All right, and another question came in. I mean, I know the answer to the question, but I mean, this will be the new contract will automatically be available in zip forms come February 1st for us to actually be able to use it, correct?
Exactly
That's
right.
correct.
Yep.
So we don't have to do any copying over or whatever. It's just we're going to wake up February 1st, click purchase contract, but you probably do need to set reset your templates, though. I'm going to
Yeah,
assume.
That's correct.
the problem we see is people that, they take the form from a prior transaction because it already has some of the language they like in it, and they just change the name and the property address. And without realizing it, lo and behold, they're using a contract from 2016. They're using a contract from 2011. They're using a contract from 2005. We see that happen, and it's because they're pulling from prior transactions. And so you've got to make sure that you're using the most recent and updated version of the form.
Scott, thank you very much for joining us. Marge, thank you as always. Again, my name is Mike Weinstein with Six Figure Mind Shift, here each and every month just to give you the broker roundtable. And we're going to have a great one for you next month, and you'll get some information regarding that. But if you'd like some more information on the new purchase contract and get 3 CE hours as well, we've got the very best coming up to West USA on Friday, February 10th, Larry Hibler from Stewart Title. If you've never sat in one of his classes, highly encourage you to do so. So we're going to send you a link right now
And
to
Rick Mack.
Oh, and Rick Mack's going to be there as well. We're going to allow Marge to communicate with him so that he might actually have the right information rather than the way that I took care of that today. So it's your chance to get some CE hours. You can't know enough about it. You may get in there and go, oh boy, I need to learn some more. So you feel free to join us, and then also give the opportunity. We've got my new book out, the 21 Habits of the Highly Successful Real Estate Entrepreneur. You can go to sixfiguremindshift.com to order a copy of that. Guaranteed to put you to sleep. No, guaranteed to change your business. Anyways, appreciate everybody joining us this afternoon. Again, guys, appreciate you joining us, and have a great day, and we'll see you next month.
Thank you.
Thank you.